everybody, this is Frekhtman, a New York City personal injury trial attorney, and today I'm talking about a Supreme Court decision that came down this week, and it has to do with the Sixth Amendment, which is part of the Bill of Rights. One of the parts of the Sixth Amendment deals with assistance of counsel. And something known as ineffective assistance of counsel means that your lawyer didn't help you at trial and didn't do what a normal lawyer would do, what a reasonable lawyer would do. And because of that, you were convicted. And now somebody is in jail and maybe in prison or maybe even on death row or even gets the death penalty because of that, right? So there were two cases that the Supreme Court heard, and there was a decision known as Shin. And basically, they were both state court cases. They were both murders, and both individuals were convicted of murder and placed on death row. And they were state court convictions. But in the past, what somebody could do was they could file a writ of habeas corpus under the Sixth Amendment to the Constitution. And then the federal court would then consider whether there's any evidence that this particular defendant received ineffective assistance of counsel, including any new evidence that the person maybe is not guilty. So what happened in these cases, one person was convicted and placed on death row, but his lawyer failed to show that he had a low IQ, that he had a history of abuse, including sexual abuse and neglect, and he had these developmental issues. And the court said that if that would have been shown, then perhaps this individual would not have gotten the death penalty, right? So that was the basis for the federal writ of habeas corpus. And in the other case, the attorney failed to show exculpatory evidence, meaning evidence that this person didn't do the crime at all, and this person was convicted. And so what the Supreme Court said in this decision, Shin, is that it wants to stop the federal courts from considering new evidence that would come from the criminal defendants and about this ineffective assistance of counsel. They basically said that relitigation is bad because it hurts the retributive and deterrent functions of criminal law. And, this is a very conservative decision because back when we had the case, the Wainwright decision back in the 60s, and a lot of precedent since then, we had this federal habeas corpus. This is the Bill of Rights. So this is a decision that really eats away at the Bill of Rights, because now if you have a conviction in a state court, and of course, you have 50 different states, you have all different courts, everyone's maybe doing it a little bit differently. And then you have new evidence, including one of these gentlemen, that it could be potentially exculpatory, but your lawyer, because of ineffective assistance of counsel, you don't know why it happened, right? The lawyer could have been sick, the lawyer could have had a drinking problem, the lawyer could have just been lazy or just overwhelmed. Whatever the reason, just doesn't present the evidence that would be exculpatory, meaning you wouldn't even be convicted. You would be walking around free right now. And he doesn't present that, and you get convicted by the state court. Now, you have this evidence, or you should get a new trial maybe with a different lawyer to show this evidence. And what the Supreme Court is basically saying is, no, you can't, because it's relitigation. You're just litigating the case over again. And we want to have retribution, basically an eye for an eye. But what if the person's really not guilty? So it's kind of like a crazy decision. The dissent, I believe it was by Justice Sotomayor, wrote the dissent, and she said that this is just illogical. And I kind of tend to agree with her, although Clarence Thomas wrote the majority opinion, and he said this serves that retributive and deterrent functions of law, of criminal law. I mean, deterrent, would that deter you? This would deter you, I guess, from committing a crime? I don't know. I mean, I suppose if, but it also eats away at that claim in the Sixth Amendment that is constitutional, right? That says that somebody, a criminal defendant, is innocent until proven guilty, and that individual has rights, right? It's the Bill of Rights. It's a very fundamental liberty here, and that they are allowed assistance of counsel, effective assistance of counsel. So let me know what you think about this, but this is another case. This came after the decision that whittled away Roe versus Wade. That was a very, very very, very notorious, and a lot of people were talking about the decision, I think it was called Dobson, that ended Roe v. Wade and said that each state has to decide abortion for themselves, and there's not going to be like a federal right. That case is also very interesting. I might do a video about that case, or maybe at least the legal basis, the constitutional basis for that decision, because it's interesting from a legal perspective, and you could maybe read the constitutional part of it, and then you could see what the courts were saying before Roe versus Wade, how they got to Roe versus Wade, and then how they're now, reversing or getting rid of Roe versus Wade and saying that it's not in the Constitution, basically. So that's another video that we could do. That's an interesting topic under constitutional law. But let me know what you think about this. This is, I think, a more fundamental right, because this is like a right to liberty and a right to justice. This is the Bill of Rights. This is, if you are wrongfully accused of a crime, and you can get something as bad as being on death row, being executed, and then you really have evidence that you didn't commit the crime, or that you shouldn't be on death row because for reasons that make sense, right? The fact that you have developmental disabilities. So then your lawyer just doesn't present that evidence, and then the Supreme Court just says, too bad, so sad, we don't care. You had your day in court, even if it was wrong and it was a mistake, we're gonna execute you anyway. That's kind of, that's kind of crazy. But let me know what you think, and thank you for watching our videos. Please like and subscribe to our videos so we can produce more content for you. And we are here for you. Our mission is helping serious injury victims and their families. Let us know what questions you have, and we'd be happy to answer them in a video, or you could text me. We'll get on a call with you and do a private free consultation. Okay, have a great day, everyone. Talk to you soon, and thank you for watching our channel.